All right, what did you guys decide?
I don't know if Mr. Kirov is back
I'm sorry.
and Mr. Slim.
It's Mr. Slim. Okay, they're not back. Never mind. I've closed all the rooms, so they kind of have to come back. I watched a really interesting series on Netflix last night, or a movie on Netflix about the trial of the Chicago 7. If you get a chance, it's really good.
I've heard that's good. I've heard that's really good.
The horrible judge in it, though, is Davis Judge Hoffman, which I don't love. But, all right. So did you guys get a chance to talk, Ms. Almeida?
I did. And quite frankly, I think based on the plaintiff's the petition and the evidence that has been admitted, I think we would like to move forward because the evidence I think is clear to the extent that the affidavits are there for business records purposes. I would ask that they be admitted. Anything that is testimony, we will withdraw. I would like, I believe Mr. Slim has already stipulated, just the one stipulation I would like is that High Tech is timely in all of the settlement payments made under the settlement agreement.
Mr. Slim, you're muted. Mr. Slim, you're muted. You're still muted.
Okay, I'm sorry. Was I muted? What are we back? You were saying, Judge?
Did you hear what she just said?
She wanted me to stipulate that the payments were timely.
Yes.
The down payment, the monthly payments have been timely. If there are any other payments under the agreement, I can't stipulate to that. Not that I'm saying it's false, I just don't know. But the down payment and the monthly payments thereafter have been timely.
And then I just said, I think we should move forward because I do think we have evidence to support our temporary injunction hearing. And that,
So what are the two exhibits then that you're withdrawing or withdrawing in part?
Exhibit, hold on. I believe it is Exhibit H.
Okay. And what else?
And Exhibit K.
To the extent there's any testimony beyond the scope of the business records, affidavits, provisions, then those portions are struck. Let's go ahead and proceed on those two affidavits.
Your Honor, would you like me to go ahead and just do my offers and get it over with?
Sure.
All right. So these are the exhibits that I had filed with the court in response to the temporary restraining order, which I had, having done this so many times before, just broadly titled injunctive relief to cover today as well. At this time, we offer Exhibit 1, which is the AQ Design lease that's currently in place.
Have you complied with because I haven't seen this, have you complied with the emergency order and emailed these both to the court reporter and the court coordinator?
No, I'm sorry, Your Honor, that's an oversight on my part.
It requires that you have emailed this by yesterday.
Yes, Your Honor, Sunday. I'm sorry, that was a mistake on my part. If the court would grant me leave to do so now, they were on the record. Well, yeah, actually, yes, I have them because they were on the record in the TRO hearing. So Ms. Rieger would have had them in response to that, for which I've already requested a record on the interlocutory appeal. And yes, the coordinator would have had that. And so, yes, I have complied.
What was that you sent them yesterday?
No, I sent them on, let me get the date. November 6th.
November 6th, okay. What exhibit numbers?
1 through 7. So
Any objection to 1 through 7?
I don't know what 1 through 7 is because, it's my understanding that Mr. Slim is saying that these are the same exhibits that he filed in response to our TRO, but I never saw anything filed in response to the temporary injunction. So, and I don't have those exhibits. I just don't know what they are.
I'll be happy to label them. Exhibit 1 is the lease currently in place between AQ Design and Vox Property.
Is that duplicative of Exhibit C that's already been admitted?
I thought yours was the old one. Let me look. I thought yours was the AQ. No, yours is the old one. Mine is the current one.
There's no objection.
One is admitted.
Exhibit 2 is the Vox demand for liquidated damages. This is duplicative, apparently, of let me find it. F2. This is duplicative of F3. I'm sorry. This is duplicative of F3. So we would offer it just, I guess, as our Exhibit 2, just for the record, to keep it clean so we know who's reporting what.
I would prefer to use F3 just because I have not had the opportunity to see what it is. And I understand counsel saying it's the same, but just because he hasn't served it on us, I don't know.
But it was served on you. It was served on you on the 6th.
Okay.
Exhibit 2 is admitted.
Exhibit 3 is an email from Miss Barger to me dated July 6, 2020. And of course, I could testify. I guess as an officer of the court, Your Honor, I'll hereby say it's a true and correct copy of the email, and it's not hearsay because it's a statement of a party opponent or representative of a party opponent.
Any objection?
No objection.
Exhibit 3 is admitted.
Exhibit 4 is the City of Farmers Branch notice of violation dated May 8th. And true and correct copy thereof, Your Honor.
I'm going to object based on relevance. I don't think it has any bearing as to whether or not Mr. Kirov has breached the settlement agreement by refusing to vacate the premises.
It's relevant, Your Honor, because this is a large part of the motivation that Mr. Johnson had to not allow High Tech to be a tenant, and which we believe, and we contend that Mr. Johnson, if Mr. Kirov is kicked out, will immediately kick out High Tech. Therefore, it goes to irreparable harm.
That
4 is admitted.
Exhibit 5, same thing. This is the email which we've discussed repeatedly, dated November 3rd, where Mr. Johnson says that he will not lease to High Tech, and under no circumstances will High Tech be his tenant.
I think that's a misrepresentation of what it is. And again, I would object on relevance because that has no bearing on Mr. Kirov's obligations under the settlement agreement to vacate the premises. There are obligations for both parties, and Mr. Kirov has violated them.
Again, goes to irreparable harm, Your Honor.
Exhibit 5 is admitted.
Exhibit 6 is an email from Amber Barger to me dated May 28th, 2020. So, statement of a party opponent, and I'll represent to the court. It's a true and correct copy as it was directly sent to me.
Any objection? 6?
No objection.
6 is admitted. 7.
Exhibit 7, which is our last one, is an email dated July 6, 2020 from Amber Barger to me. Again, statement of a party opponent through representative, and this is a true and correct copy directly off of my server.
Any objection? 7.
No objection.
7 is admitted. All right.
That's all I have.
Let's go ahead and is there going to be any live testimony by Ms. Almeida on your side?
No.
Any live testimony, Mr. Slim?
Yes.
Call your first witness.
Your Honor, we call Ashley Kuryab.
Shakira, please turn on your video.
Yes, Your Honor.
Please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do. I swear.
Let's proceed.
Mr. Kuryab, have you attempted since after March of 2020 to evict or ask High Tech to leave the premises at Gamma Road?
No.
Have you had any kind of a violent or potentially violent altercation with anyone at the premises at Gamma Road after that incident we saw on video between Muhammad and Hadi?
One time I had an incident with Firas outside the building. He was turning off the lights while we are in the building and basically shutting the doors while he's leaving, knowing that we are still in the building. So but we did have an argument, and since then nothing happened.
Well, when you say argument, was it a heated, violent argument, or is it just a disagreement?
Disagreement.
Was there any potential for violence or bodily harm?
No.
Okay. Other than the turning off the lights and closing the door on you incident, has there been any violent altercation or potentially violent altercation?
No.
Between, and let's include between any High Tech personnel and any of your personnel?
No.
Now, where are you physically right now? It appears as though you're in an office somewhere.
I'm in the new building that I leased.
Okay. When did you lease that building?
August.
Okay. Why are you still at the High Tech facility as well?
Because I cannot leave. I'm still responsible for the lease. I cannot leave. I don't know what's going to happen if I leave, because from my understanding that the landlord is still did not approve them to be in the building.
Okay. Are you in part relying, or did you in part rely on Ms. Barger's email where she said, "We understand you can't leave until we resolve this with Brian"?
Yes.
I'm going to object. I think that misstates the evidence in question and the expressed terms of the confidentiality.
Are you referring to a particular exhibit?
Yes, I am referring to.
Why don't you screen share the exhibit?
Oh, how do I do that? Exhibit.
The pandemic's
7.
been going on for 8 months. You should know how to screen share by now.
No, I haven't ever had to, but let me try to do that.
I've enabled it. On the bottom, it says screen share. Go ahead and screen share.
Oh, there it is. Yeah.
And then you can find the document on your computer.
Oh, that's fantastic. Thank you for teaching me that. No, I have not had an opportunity to do that.
All right.
Thank you. Get rid of that. Okay. Mr. Kuryab, do you see on your screen an email from Amber Barger dated July
Yes.
6, 2020?
Yes.
Your Honor, this is Exhibit 7. Can you read the first line of that email there in yellow?
I understand your client cannot move until this is resolved.
All right.
I'm sorry. I apologize, Your Honor. I had objected to this because, I think Exhibit B is the settlement agreement. This is not an amendment to the settlement agreement.
Goes to irreparable harm. This is an injunction hearing, Your Honor, not trial.
Well, the rules of evidence.
This exhibit has already been admitted, correct?
Correct.
Yeah, okay, the objection's overruled.
Well, I was objecting to the question, but
Okay, objection's overruled.
Okay. Now, when Ms. Barger says the word "this" until this is resolved, what is your understanding of what this means?
objection based on speculation.
Well, I just want to save the court some time, Your Honor. This is defined in the actual document. It's in response to my email at 2:56 p.m. there under that says, "My client cannot incur the move-out costs unless your client signs a new lease and performs on the indemnity. In this case, paying the cancellation fee." And then to which she responds, I understand your client can't move until this is resolved. Now, Your Honor, that goes to our issue of repudiation and why my client has not left.
Mr. Pirop can't testify as to what Ms. Barber meant.
Not a problem. The document speaks for itself, Your Honor. I'm just trying to speed things along. I'm going to go on to a different issue now with Mr. Curia.
Okay.
Okay. How do I? Okay, I'm going to stop the share.
Do you not want to? There you go.
Thank you. Thank you for teaching me how to do that. Mr. Curia, these boxes that were moved into the Gamma Road facility, what are they?
Which boxes you're referring to first, if you don't mind me asking?
Did you see the video clips that I sent you last week?
Yes, I did.
Those boxes.
Okay, those boxes are basically replacing equipments that I am using. One of them is broken. One of the equipment broke, and I bought a new one and received it. And another equipment, also a replacement for another equipment, because we have to have it. It's a laser welder for welding jewelry together, and the other is for casting. And they are not for refinery. Basically, they are replacing equipment, and I have an invoice for that.
All right. So do you do any precious metals refining at Ashley Casting?
No, no.
Is that what High Tech does?
Yes.
So are you moving in any equipment that's competitive with High Tech's business?
Zero, no.
All right. Have you read Faraz McBell's affidavit?
I would object. That's not in evidence. I thought I withdrew it.
Was that K?
Yes.
Let me make sure. Yes.
If you want to ask him questions about that, then you'll have to withdraw your objections and K will be admitted.
No, I appreciate. No, K. No, you're right. You're right. Withdraw that question. Thank you.
Do you have anything else?
Mr. Curia, have you had any interaction with anybody at High Tech where they've demanded that you leave the premises?
No.
Has everybody been paying the rent on time?
Yes.
Could you explain the arrangement for the rent?
We on the first of the month, I invoice them for. I give them an invoice, and they give me a check.
Do you have a written lease with High Tech?
No.
Who is the tenant at the Gamma Road location?
AQ Design. Me.
All right. So you own AQ Design?
Yes.
Does anybody at High Tech own any part of AQ Design?
No.
So how does High Tech enjoy occupancy at that Gamma Road location?
They share some of the space that we have in that building.
Are they AQ Design subtenant? Do you know what that means?
Explain that if you want, just to make sure that I understand it.
That's okay. Do they have a written lease with anybody to occupy that premises?
No.
Do they have a written lease with AQ Design?
No.
Do they have a lease with Vox Property?
No.
So to your knowledge, they're only there through your tenancy with Vox Property?
Yes.
Okay, that's what's called a subtenancy.
Okay.
All right. Also, you guys were required to share the utility expenses. Has that been occurring?
Yes.
Do you recall receiving a demand for payment of utility expenses in the last couple of months?
No.
Has there been any dispute to your knowledge about payment of utilities?
No.
Have the police been called out to quell any violence or investigate any assaults or threats since that altercation between Muhammad and Hadi?
No.
How long ago was that?
think that was in March.
Do you physically see each other in the parking lot every now and then, or in the facility every now and then?
Yeah.
And is the entire facility, for the most part, surveilled by security video,
Yes.
inside and outside?
Inside, outside, yes.
If anybody were to do some shenanigans or do something wrong, are you confident that video surveillance would catch it?
Absolutely, yes. They have a control of the most of the cameras.
All right. Your Honor, I think that's all I have.
Ross?
Mr. Karab, you and your business, AQ Inc., are still in the Gamma Road property?
Yes.
You're still operating your business out of the Gamma Road property?
Yes.
You have not told Brian Johnson that you want the lease transferred to High Tech, correct?
What do you mean?
Have you contacted Brian Johnson or Scott Miller and told them that it is your wish to have the lease transferred to High Tech, correct?
Yes.
When did you do that?
Maybe 5 months ago. Right after the settlement.
Was this contact via phone or via email?
Email.
Why did you not forward that to my office upon my request?
Sorry, what request?
I don't know.
Objection calls for state's facts not in evidence. What request are we talking about?
Well, the request he just testified. I asked him if he had requested that the lease actually be transferred, and he testified yes.
Yeah, but you said, why hasn't the email been forwarded pursuant to your request? What request did you make? If you made a request that I overlooked, I want to make it right. That's all I'm saying.
I requested this a long time ago during these lease negotiations that he do that, and you told me that he wouldn't.
Okay, I'm sorry. If there's been a disconnect, Stephanie, I apologize. Let's get that straightened out. To my knowledge, he has requested it, but I wasn't aware of any email, nor was I aware that you had requested an email. But if I did something wrong, I'll make it right. Let's talk after the hearing.
Mr. Karab, will you forward that email request to me?
Yeah.
Okay. Runner, will you share the screen for me?
I'll allow you. Yes, it's already allowed.
Oh, thank you so much. Mr. Karab, I'm showing you what has been marked as Exhibit B. Do you see that?
No, not yet.
This all meter, I can't see it either.
That's not just me.
Mr. Karab, can you see Exhibit B?
It's too small, but.
Let's see if I can focus it.
Blow it up.
I'm not sure if I can make this bigger. I apologize.
You want me to try?
I think if you. I can read it. It's just a little hard.
Unfortunately, on this sharing function, I can't.
I can read it. Let's go ahead.
Okay. Mr. Kirov, you entered into a settlement agreement with the high-tech defendants, correct?
Yes.
And you read and understood that settlement agreement when you signed it, correct?
Yes.
Okay, I'm showing you Exhibit B. Highlighted at Section K of Exhibit B, it says high-tech facility lease. Kirov shall use his best efforts to cause the property owner of the high-tech facility to transfer high-tech precious metals and refinery, LLC, or individual defendants by full novation relieving Kirov of any rights and obligations thereunder the lease going into effect in June 2020 with AQ Inc. as the tenant and Vox Inc. as the landlord, a copy of which has been provided to individual defendants' counsel. Do you see where I read that?
Yes.
And underneath that, at section L of Exhibit B, it is stated, Kirab to vacate high-tech facility. Kirab and any entity which he controls shall fully vacate the high-tech facility within 90 days of the date of the execution of the settlement agreement. Do you see where I read that?
Yeah.
And you still have not vacated the Gamma Road property, correct?
Yeah, but
Mr. Kirab, I'm asking you a simple question. You still have not vacated the high-tech property?
no.
Okay. And you were supposed to vacate on July 26th. Is that correct?
No.
90 days after this, after the date of this settlement agreement was July 26, 2020.
Can you repeat that?
Mr. Krub, I can't see you anymore.
Yeah. Yeah.
Okay. You were supposed to vacate the premises 90 days after the execution of the settlement agreement. Is that correct?
Yes.
And that date was July 26, 2020, correct?
Maybe.
Okay. But regardless, you did not vacate the premises at that time. Is that correct?
Yes.
Okay. Now, during this lawsuit, you did try to evict the high-tech defendants, correct?
I tried to do what again?
Evict the high-tech defendants, correct?
I don't recall, but tell me how.
Do you recall a TRO being issued in this case preventing you from evicting the high-tech defendants?
That was in March, maybe?
Yes.
Yes.
Because you had tried to evict the high-tech defendants prior, correct?
Previously, in the past, yes.
And the only reason you could not was because the TRO was entered. Is that correct?
Yeah.
That calls for a legal conclusion, Your Honor.
Response?
I think that's just a fact. He couldn't evict anyone because we had an agreed TI in place saying that he could not. I mean, that evidence is on the record. It's part of the case.
But remember, that was before the settlement, before the dismissal, Your Honor. He was still part of high-tech and therefore was a fiduciary. The underlying premise has changed dramatically.
Judgment's overruled.
So, Mr. Carab, I'll ask the question again. The only reason you were not able to evict the high-tech defendants was because the TRO was in place, correct?
I guess.
Okay. You and the high-tech defendants do not have a warm and fuzzy relationship, correct?
Object to form, it's ambiguous.
Yeah, that is kind of ambiguous. Go ahead.
I'll rephrase.
We'll stipulate.
Well, you are no longer business partners with the high-tech defendants, correct?
Yes.
You do not visit with the high-tech defendants for friendly conversation, correct?
No. No.
You and the high-tech defendants' families do not get together anymore, correct?
Yes.
Okay. Would you agree with me that you and the high-tech defendants are not friends?
We don't talk.
Okay. And you no longer want to do business with them, correct?
Correct.
Okay. I apologize, I'm scrolling down to the next. You discussed moving equipment into the premises. When did that occur?
Last week.
So you were moving equipment into the property, correct?
Casting equipment.
Yes. And you have no intention of moving out of high-tech property, correct?
No.
Okay.
I'm sorry, Your Honor, that was ambiguous. I'm not sure the way the negatives worked out. Could we get some clarification on that?
What does that mean exactly?
Well, she asked, you have no intention.
No, I was asking Ms. Almeida.
Oh, thank you.
Mr. Karab, you do not intend to vacate the Gamma Road premises, correct?
No, I want to move out
Okay. Why have you not? I mean,
because there is no agreement with the landlord yet.
you understand that the settlement agreement does not require an agreement with the landlord.
But
Objection calls for wait. Calls for a legal conclusion, Your Honor. The contract has to speak for itself as a matter of law.
I think it does, Your Honor. It states that he has to vacate the premises within 90 days.
If you read that in isolation, yes, but you have to read the paragraph above it, Your Honor. Everybody thought the novation was going to occur within 90 days. That's why that's in there.
Let's move along.
Okay. Mr. Kirab, I'm going to show you what's been marked as Exhibit D.
Okay.
This is the notice to vacate and the termination of lease that you sent to High Tech on March 23rd, 2020, correct?
Yes. I cannot read it, but I'm assuming. Yeah.
Okay. Mr. Kirab, did you see Faraz Mekbel at the Gamma Road premises on Saturday, this past Saturday?
This past Saturday?
Yes.
No.
In the past week, have you attempted to spit at Mr. Mekbel?
No.
You discussed that you did have a verbal altercation with Mr. Mekbel, however, correct?
That was 2-3 months ago.
Okay. And you've had, and it's your testimony that you've had no verbal altercations with him since then?
No.
Have you thrown water underneath the door in the High Tech facility?
No.
How would water from your portion of the property get into the High Tech portion of the property?
I have no idea.
Are you aware of any leak?
No.
Okay.
Nobody told me anything.
Okay.
Normally, whenever there is a problem, we notify each other. We talk to each other through other people, but nobody told me anything.
Okay. I'm going to object to the non-responsive portion. And just for the court, I am showing Exhibit J4, which is a screenshot demonstrating. These are screenshots, and this demonstrates, Mr. Kirab, you moving the equipment into the premises. Is that correct?
I'm assuming these are the two equipments that we received last week. If that is, yes, those are two equipments, yes.
Okay.
And I have an invoice for that.
Okay. No further questions, Your Honor.
Redirect.
Mr. Kirab, did you authorize a name change of your AQ Inc. or AQ Design to High Tech Precious Metal Refinery?
No.
If you would, that screen you have in front of me, I know it's kind of hard to read. Do you see certificate of occupancy?
Yes.
The very last line, condition. Can you read that? I know it's difficult, but try your best.
I can't.
You cannot?
No.
If the court can read it, Your Honor, I'd like to read it into the record.
Sure. Miss Lee, you said there's a magnifying glass on here. How does that work?
Where that little URL is on the right-hand side where the favorite star is, right before it. You can hit that magnifying glass and you should be able to zoom it in or zoom out.
Let me see. Oh, I can't do it. He can do it. I can't do it, right?
Oh, I can do it?
Whoever's screen sharing it should be able to do it, I think. Is that right?
Yes.
I see it. Oh. Hold on, here we go.
Yeah, that's a lot easier to see. Okay, go ahead.
Can you read it now, Mr. Kuryab?
Can you read it for me?
I will, if the court will let me.
Sure.
It says conditions, semicolon, 1, CO, meaning certificate of occupancy, CO represents a business name change. So, sir, who had the certificate of occupancy on the premises prior to October 2020?
Can I object to relevance? I'm not sure what the purpose of this line of questioning.
Why is this relevant?
Because the CO was one of the conditions that Mr. Johnson said he wanted, and that's in evidence, to enter into the lease with High Tech. And one of the reasons that High Tech cannot get Mr. Johnson's cooperation is it's a fraudulent CO. Now, mind you, this is.
I'm going to object. None of this is relevant to the pled claims. He's also misrepresenting what happened with the City of Farmers Branch. That's facts are not in evidence.
They're asking for equitable relief, Your Honor, and they put this in evidence. I did not object to it. It is admitted, and it is now evidence of unclean hands. There is no name change of a prior occupant, and High Tech did not, in fact, get the proper CO. So even that condition wasn't met, Your Honor. If they want equitable relief, they got to show up with clean hands.
Okay, let's move along.
Who had the certificate of occupancy, Mr. Kuryab, prior to October 2020?
I do.
You or your company?
My company.
Which company? Do you remember?
AQ Design.
Okay. And did AQ Design change its name to High Tech Precious Metals Refinery?
I'm going to object again to relevance. I do not understand why this is important as to why Mr. Kuryab has not vacated the premises. This is also, the City of Farmers Branch put this on here. There's no request from High Tech to do this. So I think it's irrelevant and it misstates the facts.
I'm happy if High Tech wants to withdraw the exhibit, but while it's evidence, I get to challenge the evidence.
Overruled. We can move along.
Okay. Mr. Kuryab, is there a surveillance camera in place which would show the area between your space and High Tech space?
Yes.
If somebody were to put water under a door or somehow infiltrate water from your space to High Tech space, would that be on video?
Yes.
Likewise, if there was some spitting incident of you or somebody trying to spit on somebody else inside or outside of the building, would that likewise be on video?
Yes.
To your knowledge, have you been presented with any video evidence of these incidents?
No.
Although you don't get along with High Tech, are you and your staff mostly peaceful with High Tech and High Tech staff?
Absolutely.
Pass the witness.
No further questions, Your Honor.
Call your next witness.
Your Honor, I'll call myself. If I could be permitted to testify as the narrative form.
What are you testifying about?
I was a point person. Amber was a point person on the High Tech side, and I was a point person on our side. And I'm happy to just go ahead and start talking if you'd like. Can I have my screen back? How do I do that?
I can stop sharing the screen. Hold on. I think I want to object to the scope of this testimony. I am not sure what Mr. Slim is seeking to accomplish here. I mean, we can open it up to argument, closing argument, but as opposed to just a narrative form of, testimony in this case from counsel.
I communicated with Mr. Miller. I communicated with Mr. Johnson. I communicated with Amber Barger. So they made a point. They made a point, and it's in evidence because they cited that provision, which I was referring you to earlier, that Ashley Kuriab should use regular business, good faith business practices in trying to get that lease for High Tech. And I'd like to testify to Your Honor that yes, we did. And I'm happy to tell the court what I spoke with Brian about, what I spoke with Scott about, what I spoke with Amber about. And a lot of it is in the emails, but there's maybe stuff that isn't.
Well, then if it's in the emails, then I would direct Your Honor to that. Because if Mr. Slim believes now that he's a fact witness to this, then I think he should remove himself as counsel.
Yeah, that's what I was saying. If you really want to testify, I don't mind if you testify about attorney's fees, but at this point, it seems like you're kind of making yourself into a fact witness and you really shouldn't be counsel.
Okay, I don't have to do that, Your Honor, because right when I was talking, I got a ding on my email, and it is an unsworn declaration of Scott Miller on Scott Miller's letterhead. And I just now received it, and I wanted to see it last week, but I'm just now getting it now. So I'd like to offer this as our Exhibit 8.
Well, quite frankly, if my client's affidavits couldn't be used, I don't think the unsworn declaration of Mr. Miller should be admitted.
That definitely doesn't comply with the local rules. I mean, or with the, sorry, you said local rules, we gave you a hard time. Sorry, the emergency order that needed to be submitted yesterday. Why don't you just do this in closing? I mean, it doesn't really need to be sworn testimony on this.
You raise a point, Your Honor. I don't think I have to disqualify myself because I was acting as an attorney, and it's not necessary to the ultimate merits of the case. It's really only as to this interlocutory relief. And that's why I would offer this affidavit, which is going to say substantially what I was going to say. I'm reading it now. It's a very short affidavit or declaration.
Why don't you share it with Miss Almeter so she can look at it and then she can make a determination?
Yeah, let me do that. Let me do that right now.
Just send it directly to her.
Okay, I'm just hitting send on the email right now, Stephanie. And rather than doing it all in a motion for reconsideration, et cetera, I just love to get it over with now.
Well, I mean, I haven't looked at it yet, obviously, but I'm also going to object on the basis of relevance because, again, as this court understands, Mr. Karab was supposed to vacate the premises, regardless of anything with the landlord. High Tech agreed to indemnify. So I don't believe, number one, that it is right to have a declaration of someone admitted when we've agreed that, we were not going to do testimony via affidavit, as Mr. Slim has now stated, and it's irrelevant. But
I can try to reach him on the phone. Maybe we can do it that way. But this is it's exactly what I was telling you last time, Judge. I mean, can I send it? I can send it to you as a bill. May I do that, Your Honor?
I haven't made any rulings as to this. I just my general thought is just if you really want to call him, if you can't call him live, that I would give Ms. Almeter an opportunity to depose him, just like I said before. But
let me try to reach him. I hope I have his number. I do have his number. If the court would indulge me.
Okay.
Linton Miller.
Can I have Scott Miller, please? This is Jewel Slim.
He is not in the office right now. Can I take a message?
It's rather urgent. We're actually in a live court hearing right now, and I need to reach him pretty urgently.
You need to call his cell. He is not here.
Oh, that's great. Yeah, I know. I got that. What's his cell?
214
Okay.
258
Yes, ma'am.
8771.
8771. Thank you so much.
You're welcome. Bye.
Hey, Scott, Jules.
Hey, did you get that?
Yeah, I got it. Listen, you're on the record right now. I've got you on speakerphone, and we're doing a Zoom hearing.
Okay.
So we're having an issue right now about getting the affidavit admitted into evidence. So I offered your testimony live. So thank you for answering the phone. Your Honor, can you hear Mr. Miller?
Yes.
Okay. Scott, can you hear the judge? Did you hear the judge say yes?
Yes.
Okay.
I still have not seen the affidavit, just so we all know that. Okay.
Well, let me check my sent folder.
Because if Ms. Almeida doesn't object, then we don't need this live testimony. I hate.
Yeah, exactly. It's either the affidavit or the live testimony. I sent it 12:32. You want me to send it again?
Sure, I don't have it.
Okay, let me send it again.
I mean, I will tell you, I'm objecting to the scope of testimony because Mr. Is it Scott Miller? Scott Miller is not the landlord. He's just the broker.
There's more than that, Your Honor. He is the actual agent, the leasing agent, and he's absolutely in. You'll see even on the certificate of occupancy, Your Honor, Mr. Miller's company is listed as owner. So it's not, leasing agents are much more than just.
Well, again, it doesn't have anything to do with the fact that Mr. Kirov was supposed to vacate the premises and he has not.
It has everything to do with the elements of equitable relief and irreparable harm, which is what we're here on.
Guys, can we just figure out if, I hate to keep this gentleman on the phone, have you emailed Ms. Almeida?
Yeah.
I sent it twice now.
Do you have it, Ms. Almeida?
I'm forwarding it to Ms. Barker as well.
I'm sorry, I should have included her. Now that they have it, again, Your Honor, you want to give them a 2-minute conference?
If she can agree to it, I'd rather just I hate to have Mr. Miller just stay on the phone.
Yeah, no, I understand. I appreciate you being patient with us, Scott. Thank you.
No, I appreciate it. I think, I can agree to it. I would say that, again, the section 4 of the I do not object to paragraphs 1, 2, 3, and 5. I just think section 4 is irrelevant as to the issues before the court on this matter.
Your Honor, may I read section 4 into the record in camera?
Sure.
All right. Section 4 says, neither Bolins and Miller Realtors, Inc. as agent for Vox Property LLC, nor does Vox Property LLC have any intention of entering into a lease with High Tech. The only reason that High Tech occupies the premises is because of AQ Design LLC's lease on the premises. There is no scenario where High Tech will be allowed to stay on the premises without AQ Design LLC's continued occupancy thereon under its lease. If AQ Design LLC is forced to move out of the premises, High Tech will no longer be a legal occupant of the premises, period.
Again, based on relevance, there is no reason why that is relevant in any way as to Mr. Kirov's obligations pursuant to the settlement agreement.
It's relevant, Your Honor, because one, irreparable harm, the only harm that will come to High Tech is if their relief is granted. And it's also relevant to damages because there's no scenario where High Tech will be able to stay on the premises. Therefore, they can't possibly be harmed by AQ Design's occupancy thereon. So they lose on probable right. They lose on probable harm, Your Honor.
That is absolutely incorrect because the harm they have is that Ashley, Mr. Kirov, will be allowed to stay on property that they already agreed that he would move off of. They already agreed that that is what happens. 90 days after the settlement agreement was signed, Mr. Kirov was supposed to leave the premises. He's actually already testified that he already has another leased space.
Exactly.
Our duty to, please do not interrupt me. I have not interrupted you.
Yes,
the
ma'am.
agreement was clear. The agreement was clear. Mr. Kirov has another space that he can move into, right? Our High Tech's duty to indemnify does not occur until after Mr. Kirov vacates the premises. So the harm that will happen is that the party sat there and worked out after a difficult and intense litigation, a settlement agreement that now Mr. Kirov has just decided that he is not going to abide by. That is the irreparable harm. These were savvy business owners that created a solution, and now Mr. Kirov is going back on his word. So that is the irreparable harm. That is the probable right to recover. He admitted he's still on the premises, even though he was supposed to be out as of July 26, 2020. So this testimony from Mr. Miller, who is the brokerage agent, it's irrelevant as to what we're here today. And this convoluted, argument from Mr. Kirov and Mr. Slim, it doesn't hold water. We've already agreed. The settlement agreement and its terms were very clear.
May I respond, Your Honor?
Sure.
Get to a jury verdict. Mr. Kirov, did you breach? Answer, yes, he didn't move out. What are the damages? Well, let's calculate damages. If Mr. Kirov moved out and High Tech is made to move out, could High Tech then charge Mr. Kirov for occupancy of the premises? No, because High Tech doesn't have any right to occupancy itself, and therefore under no scenario can be a sublessor or a lessor to AQ Inc. They're trying to create a scenario, Your Honor, where you are forcing a contract on people. They're trying to make you create a leasing.
No.
Hold on. A leasing arrangement on a contract that doesn't exist that wouldn't otherwise satisfy the statute of frauds. There's no scenario on which a jury could answer anything but a big goose egg on damages, but because the only reason they're in that property is because Ashley Kirov is in that property. And to have him leave and them consequently leave places them in a position where he's the only one keeping them from being harmed. That's the irreparable harm issue they lose, and that's the probable right issue they lose. They have no right to occupancy, therefore they don't have any harm, and they can't possibly be irreparably harmed by AQ staying there.
Have we released Mr. Miller?
Well, Your Honor, may I offer paragraph 4 in conjunction with the remainder of the affidavit?
Exhibit, what is it, I?
8.
Is that what it is?
8.
8.
I don't have it.
Exhibit 8.
I'll send it to you.
Exhibit 8 is admitted.
All right, I'm going to send it to you guys right now. All right, Rhonda Pinson, Tony Rieger. Tony Rieger, I'm sending it to your Yahoo. Is that okay?
Can we let Mr. Miller go now?
Yeah, Scott, thanks so much. I'm going to hang up on you now.
Okay, thank you.
Yeah, you bet. Bye. Your Honor, do you need a cause number on that?
Yeah, it'd be great. DC 202395.
02395. And I'm going to put in all caps Exhibit 8 in the subject line. I'm going to hit send right now. And I sent it to Rhonda, Tony, and you.
Is there anything else?
No, I think that covers everything I would say as a witness, Your Honor.
Okay. Call your next witness.
No further witnesses.
Defendant rest.
Defendant rests. Well, we're plaintiff. I'm sorry.
Plaintiff, yeah, we're going in opposite orders here, but respondent, I guess, rest.
Respondent rests.
Okay. All right, the court is ready to rule. I'm going to go ahead and grant the temporary injunction. We have to determine a couple of things, I guess, here. One is we need to provide a bond. Court is going to order a $500 bond, and then we need to set a trial setting. Was this a jury or non-jury case? I don't recall.
We would be,
Jury.
I don't think we specified, I would be fine with a bench trial. I will note for the court that we have a December 28th MSJ hearing date that that might dispose of all of our claims.
I still have to set a trial date, though.
Yeah.
The reason I ask is it just is going to determine when I set the trial date, if it's going to be jury. What was it set for before?
It's good.
You
I'm
know.
looking for the trial notice if we had one.
Let's see.
I don't see one.
We surely had a trial setting.
I don't see one in my.
I don't know if we did.
We had, did we ever do an actual temporary injunction in this case? Or
No, we just kept extending the TRO by agreement,
Okay.
which was fine. Everybody was getting along. We were doing fine.
Has there been a jury demand or no jury? I mean, I guess the real issue is, do you plan on having a jury or not a jury?
Yes, we would. If there hasn't been a jury demand, we would request one.
Okay. How much time do you need to get this case ready for trial?
Well, we filed a fraudulent inducement claim. Depending on whether this court has jurisdiction, Your Honor, there's a parallel case right now. And the Court of Appeals is going to determine jurisdiction, hopefully in the next couple of weeks.
There's a fraudulent inducement. I'm not sure what you're talking about.
Yeah, we filed a case against High-Tech's people in High-Tech a couple of weeks ago that they fraudulently induced us into the settlement agreement because they failed to disclose or fraudulently disclosed financials. But since this case kind of, reinstated, it may not.
That case should come back here.
Yes.
Yeah, no, yeah. And I put a certificate of transfer on that. It would come back there. So I'm not sure exactly what the status.
Would you anticipate consolidating that or have a different trial? I don't know enough about that case.
Yeah, if you have jurisdiction, and like I said, the Court of Appeals is going to make that decision here in a couple of weeks. If you have jurisdiction, I'll dismiss that case and we'll just amend here because the parties are positioned exactly the same. There's no reason for a new cause number. If you don't have jurisdiction, then we kind of all move over to that case. And
so for this trial, all I really need to do is for this particular cause number, when do we need to set this for trial?
Spring will be fine.
Ms. Almeida?
I would say probably, July, maybe July, August.
I'm fine with that. I could live with that.
Okay, let me just look it up. July 13, 20, or 27? What day do you want?
I'm getting there. So
Okay.
July 13, 20, or 27. 13 I'm blank. 20 I'm blank. 27 I'm blank. Toss a three-sided coin.
Almeida?
Let's do the 20th.
Okay. All righty then.
And Your Honor, just so you know, I doubt you'll see us.
I hope not. This case was settled. I hate to have cases come back that are settled.
I understand. So Tuesday, the 20th.
Yeah. Can you just put that on my desk? Okay, guys, anything else?
No, Your Honor. I saw the form of order. I know you lined out the TRO. Are you just going to basically copy the TRO into the TI? What all that laundry list of stuff?
We filed
Did
a
you not-
proposed TI.
Did you see the proposed TI order?
I did. Let me look at it again. Boy. There it is. 5 pages.
Thanks.
Okay. I mean, would you like me to go through one by one and state objections, or?
Is it consistent with the temporary restraining order? I guess.
Oh,
That's my
yeah.
question.
It appears to be, but I mean, you understand, H, you're enjoining Curiab from terminating the rights of High Tech from the month-to-month tenancy. That's you drafting a lease that doesn't exist. Causing criminal proceedings, I think you line that out of the TRO. I assume you're going to line that out of this one as well.
I think that's correct, and I would agree to remove I.
Plaintiff must provide copies of all monthly rental payments made on behalf of High Tech. All right, well, we don't do anything on behalf of High Tech. K, instigating fights. Interesting. Trespassing. Okay, trespassing on a High Tech property, Your Honor. It's not, none of this is High Tech's property. This is all AQ's property. So that M is not supported by the record or law. Making defamatory comments, and there's nothing in the record or pleading to support that grant. O, plaintiff cannot defame or make representations about High Tech's proposed tenancy, ability to pay, etc. There's nothing in the record which supports that. And going back to the top, A, remaining on the premises in breach of the settlement agreement. That's not irreparable harm, Your Honor. It's simply possession of a commercial premises that has an adequate remedial law. B, plaintiff counter-defendant must vacate the premises within 14 days. I don't think the court has the authority to do a detainer action here, much less by injunctive relief and not trial on the merits. There's also no evidence, and quite frankly, contrary evidence of irreparable harm or harm at all about plaintiff vacating the premises. C, initiating eviction proceedings. Mr. Curia testified there is no eviction proceeding, nor is there any intent to evict. They brought up something back in March before we ever settled that simply hasn't been reinvigorated, and he said will not be. That goes to D as well, changing the locks and access, nothing in the record or pleadings to support that. Restricting individual defendants' access to the premises, nothing in the record to support that. He testified completely the opposite. He has no intention of interfering with their occupancy. F, asserting a lien or encumbrance of any kind against High Tech's equipment, fixtures, furniture, nothing in the record to support that. Nor has there been any testimony to that effect or pleading to that effect. I guess I'm being redundant. And per his own testimony, he has no intention of doing so or interfering with High Tech's occupancy. G, using any High Tech's equipment, fixture, furniture, and inventory. Your Honor, that was a remnant from the old TRO when he was still part of the company. It's no longer relevant now, nor is there any pleading or record to support G. And H, now we're coming back full circle, terminating the rights of the month-to-month tenancy. So confessing right here in the document that it's a month-to-month tenancy, therefore they're causing you to create a lease of indefinite time in violation of the statute of frauds and in violation of law that clearly says a court cannot draft a contract that doesn't exist. So, Your Honor, this is all just unsupportable by fact, law, and pleadings. None of this is good. So we object to everything I just itemized.
Response?
I mean, I disagree. We followed the letter of what was granted in the TRO. You know, we're not asking the court to enforce or create any contract. You know, Mr. Slim himself sent an email saying, originally sent a letter demanding that we vacate the premises for the sublease agreement. In fact, we are simply just trying to prevent Mr. Kirab from, evicting or doing anything to interfere with the ability for High Tech to have day-to-day normal operations. And this was the TRO that was granted originally. And the only reason that High Tech has not been evicted was because this court issued injunctive relief preventing Mr. Kirab from taking these actions. He's already tried to do it. There is bad blood between the parties, as evidenced by a physical fight and Mr. Kirab's own testimony. And quite frankly, even though Mr. Slim and Mr. Kirab want this case to be about something different, this is about a settlement agreement, a contract that both of the parties entered into that resolved all issues that Mr. Kirab is in breach of and continues to breach. And that is what this case is about, that it is a simple case, and Mr. Slim and Mr. Kirab want it to be about something different. So the temporary injunction, adequately protects my client's rights.
Just so it's clear, the only thing you wanted me to take out is the section about the criminal.
I believe it was section I. I think that was taken out of the TRO, and that was agreed to, and Mr. Slim is correct on that.
Okay, guys.
On the
go ahead and
bond,
enter the temporary. I'm sorry. Go ahead.
on the bond, Your Honor, if the court gets it wrong, the bond should cover Mr. Kirab's damages. If we're right, and if we prevail on the appeal, and if the appellate court doesn't just punt on jurisdiction and actually gets to the merits of the issue, and I argued it both ways in my briefing to the appellate court. Ms. Almeider's briefing is due in a few days. The damages that Mr. Kirab would suffer with the expense of moving and the business disruption would be substantially more than $500. And we also know from the evidence in the record that the cancellation fee is somewhere between $42,000 to $96,000, or $46,000 to $92,000. I've been juxtaposing that number in my head sometimes. So the bond should really be more reflective of those figures. And I had asked Miss Barger months ago. I said, look, put the money into an escrow account, a neutral escrow, even Miss Barger's IOLTA account. Put the cancellation fee into IOLTA, and we're out of there, because we were so concerned about the repudiation. Now,
let me give you two options here.
Sure.
I'll either do the 500, or why don't you have your client return all the settlement proceeds he's been paid? Miss Barger will put $42,000 or whatever the cancellation fee is. We go back to a standstill, and I'll issue a higher bond. How about that?
we might look at that, Your Honor, if the court would, if you really want to do that and pretend no settlement occurred, then go get Mr. Shamoon in place, go get an actual accounting in place, go get look at the actual contents of the vault and all the bank account shenanigans they were doing. But I'm pretty sure the court doesn't want to do that. And I'm pretty sure Ms. Almeida doesn't want to do that. So all I'm speaking to is the merits of the bond. If you're forcing him to move out, there's a cost to that they should cover and indemnify, and that includes the indemnity agreement itself. We don't have to hit the rewind button all the way back to March. We just have to apply the law on injunctive relief as it currently exists. The bond is substantially more than 500.
Ms. Almeida?
Well, quite frankly, indemnifying Mr. Kirab for his move out costs when he already agreed to move out per the settlement agreement is just contrarian and makes absolutely no sense. As this court is aware, and the Texas case law makes clear, our duty to indemnify does not, incur on High Tech until after Mr. Kirab moves out, and there are some indemnity penalties created. So at this point in time, again, we're just asking the court to enforce what the parties have already contractually agreed to. We are not looking to rescind the settlement agreement because I don't think it's positive for anybody in this case for these parties to be actual business owners. Again, we do not want to rescind the agreement, but we want to enforce it. And the parties have already agreed as to what that looks like. So I think a $500 bond is appropriate in this under the instance.
Okay, great. I'll go